This Honorable Court of Tennessee is now in session. Please be seated.
Good afternoon. Call the first case, please.
Victoria Jensen versus Tyler C. Jensen.
We'll hear from the appellant.
Lisa Bowman here for the appellant, Tyler Jensen. Good afternoon.
Good afternoon.
This appeal has been filed on behalf of Tyler Jensen for several issues, but primarily...
You want to reserve any time for rebuttal?
No, sir.
No? Okay, go ahead. Proceed.
There's only one agreement that we had, and so for me to have the last word against Mr. Konvalinka would probably just be a waste of rebuttal. What we do agree on, though, is on page 18 of his brief, the only agreement we have is that the court awarded his client $100 a month as transitional alimony, but didn't say when it would end. The reason that the notice of appeal was filed in this case is because the chancellor...
Could you pull the microphone down just a little bit more? Thank you.
The record indicates that the chancellor found that Mr. Jensen was not credible from the very beginning. Unfortunately, that credibility finding continued to follow Mr. Jensen throughout the trial. But the result was an inequitable division of property. And what we're asking you to do today is to take a look at this and to see whether or not, even though equitable does not mean equal, whether or not this inequitable division is fair to Mr. Jensen, the appellant, under all of the circumstances. But there's mathematical errors. We do also agree on that. The extent of the mathematical errors, I believe, shows that my client received even a greater debt because although there are certain values listed to assets that were awarded to him, those bank accounts at the time of the trial were actually zero. However, the record does not indicate that the trial counsel introduced the bank statements to show, as of the date of the division of property, that the balance was zero. The disposition or dissipation of assets issue in this case was greatly disputed. The court found that over $130,000 based on a chart prepared by Mrs. Jensen was dissipated by my client and awarded her a 50% cash payment from those funds. Now, this was only an 11-year marriage, and at the time, or presently, the children are, I believe, almost 10 and 12, almost 13. About those ages. I don't want to misstate their ages. They're still very young. And so one of the primary issues in this case is the parenting plan. 9 years old and 12 years old. Thank you for that minute. And so the parenting plan with my client living in the state of Texas provides that my client has to have reunification counseling. There aren't really many counselors in our area in Chattanooga that do reunification. But one of the main things that's ever going to prohibit him from having any sort of reunification with his children is it can't be by Zoom, and he lives in the state of Texas. He relocated in the state of Texas prior to the final hearing. He's always been in the state of Texas, and the chancellor specifically found that he could not do the reunification by Zoom, or not virtually. So don't make me narrow it down to the word Zoom. That's my mistake, but virtually. Well, if you're in Texas, you cannot come to Chattanooga. It's not financially feasible, and it's just impossible to come for counseling sessions unless you're allowed to have access to your children. And so we're also asking the court to find that that was an error and that it is more appropriate and in the best interest of the minor children to at least allow some reunification because it has been so long since he's seen his children. Right now he basically has holidays only. The mother's parenting plan was adopted in total. The father's parenting plan...
He chose to move to Texas, did he not?
He did choose to move to Texas, that is correct. He moved in Texas, I believe, March of 21, and no, not March of 21. The hearing was in September of 22, but it was the year before in 2021. I'm not sure it was March. He did move to Texas voluntarily. The argument is that he never really, or he didn't move for work. He did move to the state of Texas. He did subsequently file bankruptcy. which is another issue. There was an award of $64,000 in attorney's fees that was granted against him while the bankruptcy was pending. And I know the position is that it was for current support, but there was never any proof that she had spent $64,000 in attorney's fees or that it had come out of her household in order for it to be a current support obligation. And he is not automatically financially responsible for her attorney's fees. She made a lot of money herself. The brief indicates on the appellee that her income was net $8,000 a month. Her income was over $11,000 a month gross. She never lost a country club membership. Her private country club, I think they had 3 or 4 of those. Those meals were continued to be ordered throughout the divorce. And so this case tends to turn more on the division of property, the allocation of debt, the parenting plan seems to be more punitive than it does equitable. And I realize that you have to find an abuse of discretion and that there has been a credibility finding. And that's one of the hardest things to overcome for an appellant, since the trial court is the one that had the opportunity to observe him. There were a couple of hearings that he was not present at. He was in the state of Texas. And I cannot make excuses for that. I was not trial counsel, but as on an appellant level, there's things that need to be fixed. It needs to be fixed that the distribution was wrong. All of her figures on pages, I believe, 13 and 14 are wrong. The award of transitional alimony of $100 a month is not a true transitional alimony of $100 a month award. And the trial court did find he did not have the income to pay alimony, but yet still ordered him to do so. Well, then one of the issues that was still pending after the memorandum opinion was the entry of a parenting plan and child support worksheets. There's a supplement to the record on that issue. That issue that came up on the child support worksheets includes a daycare expense that had not been on any previous worksheets in the past. So it came up as a third contempt. And the memorandum opinion said this was what your support will be. In the face of the third contempt, it's like he was relying on the court's opinion. The court said, well, it wasn't the final order. But it clearly says, moving forward, this is what your obligation would be. The court said that was very clear that that's not what it was intended to do. It was modify an order from 2 years before that said his support at so much more. So he was found in contempt again for not paying a previous order, and additional attorney's fees were granted. And then the child support worksheets were changed to include a monthly aftercare expense that for the first time came up post final hearing. Now, it's like the case was stayed for a while and he did bankrupt on the credit card debt. So now that credit card debt is no longer owed by him. And so even though there was a mistake made in the beginning of the court's opinion and the bankruptcy eliminated his obligation to other creditors, it didn't eliminate his great obligation. All the arrearages, all of the payments that he was ordered to make pursuant to an agreed order, and never got to the court and asked for a modification. But the change of circumstances was found to be an intentional reduction in his income. And I believe there was plenty of testimony to prove that he voluntarily moved to the state of Texas, but his income was slowly being reduced. He was not making in Tennessee what he was earning in the state of California, which is where they lived the first years of their marriage when they got married back in 2011. And the private school tuition is another disputed issue, but the issues that were raised in the appeal basically are the inequitable division of marital property, the parenting plan being almost absolutely impossible, the award of alimony to her, which is not of a specific duration, nature, and amount, and that the trial court erred in awarding $64,000 in attorney's fees while the bankruptcy was pending. Thank you very much.
Thank you. Hear from the appellee.
Good afternoon.
Good afternoon.
John Konvalenka for the record. Council and I agree on another matter, which is there is a issue with her client's credibility. I mean, the judge found this individual was not credible with regard to his statements that he made. He was not credible in why he did not pay. He was not credible with regard to his expenditures. There was a situation in which I assume the court was aware that we had a hearing scheduled for a contempt matter because he was not paying his child support and he was not paying the bills that he was supposed to pay. And he submitted a false COVID test, claimed he was sick with COVID, and he could not appear at the hearing on the scheduled date. And that hearing was in February, and it was moved to March 30th. And of course, it was discovered thereafter, and it was in the proof, that there's a video that's attached to the record that shows that he was out exercising on the day of the hearing. He was running. He was going to the gym with other people present without a mask. He was, as pointed out in our brief, he was charged with assault, and he was under a no contact order with our client, but he was also under an order not to use alcohol because part of the problem was his use of alcohol, in which he assaulted his wife with the children present. And so he also, on the day that he was supposed to be at the hearing, and my point about mentioning that, he bought alcohol. So he went to the liquor store, took pictures of him with alcohol, and then he also left, and he was riding with somebody else with alcohol in the car. This gentleman, if you will, he's been sanctioned by the court, but he has not suffered really any sanctions because he hasn't really paid anything. And he continues not to pay anything. The question is, yes, he chose to go to Texas, and I think you know that he chose to go to Texas because he was having an affair with this other woman that lived in Texas. And that's what the argument started when he was drunk at home and assaulted his wife and the police came. So yes, he is a person that has issues, and he should not, he should be seeing a counselor, going to rehab or something, but he's not doing any of that. The court also judicially found that he had ability to make more money, that he was willfully underemployed. I mean, he quit his job and moved to Texas. He actually works for a company now that's in Wisconsin, not in Texas. He has the ability to return to Chattanooga. In fact, he had an ability where he rented an apartment for a year and paid $2,500 a month on that apartment and stayed there a total, depending on the testimony that you believe, all he admits is to a total of 1 month, if you count all the days that he says that he was there. There's some dispute about the number of days that he's actually there. And so, again, there's no dispute that during this period of time, he was provided time to see the children. He was to contact our client around Christmas so he could have them for Christmas Day. He did not do so. He did not see the children until the 27th. So he's seen the children in person from maybe 2 days since the hearing on this case. He did see more when he was in Chattanooga. Again, there's a situation in which it's a boy and a girl, especially the young girl, according to the mother, on her testimony, says that she's shy and that she believes reunification therapy is essential and that it should be done in person. And the claim, of course, is, well, they can do it all virtually. And no offense, again, with a child, the attention span of a child on a Zoom, I would question that. But again, I'm not a doctor. So I will say there's been no efforts to have even a virtual conversation via Zoom or whatever with these children. There's no ban on that. There's no restriction on that he has to do everything in person. He could be doing in Zoom meetings with them, maybe getting them acclimated to maybe doing therapy, being virtually. He has chosen not to do that. He has chosen to live with someone else and her son and ignore his own children, which is sad. But it's happened. So we at least, I think, maybe now I understand that council agrees with me on the standard of review. There is some, in her briefing, there was some suggestion that there was something other than abuse by the court. There's no, all of these are governed by abuse of discretion. So again, there is, in this proceeding, this judge spent a lot of time formulating her opinion. Now, there is a mathematical error. Not all people who are good with math, or maybe the person who helped her with the math, there is a mathematical error that's with it. If Ms. Lomax would, I would like to show you 2 pages from the record and why I think what the reason for the mathematical error is and what it should be. But at the end of the day, with regard to this mathematical error, the error would cause him to be further in debt based on her ruling. And what actually happens is it's going to be less than debt. So, for example, this is an excerpt from her final decree, and I'm looking for the record. 315 is the page of the technical record. And what you have is a description of husband's assets, and I, being old school, used a adding machine to add these numbers up. And so if you look, I've highlighted in yellow the numbers on the far right that indicate what the husband's assets are, and I've highlighted in the middle on my adding machine that it's $155,852. In actuality, Ms. Bowman's brief agrees with that number. So, again, on liabilities, which unfortunately takes 2 pages, there are numbers at the bottom of page 315 and at the top of 316 that are pink, if you will. And I show the numbers that on the 315 on the far right or on my tape that's in the middle. And if you flip the page, the rest of the numbers are in the middle, and the numbers that are listed in pink are there. And those add up to be 182,188. That is a negative 182,188, because those are debts. And what is in green that follows are exactly the same numbers. And those are duplicates. I have speculation, I don't have knowledge as to how that occurred, but if you look at the description on the left, one of them has credit card numbers, and if you look at the page before, they just reference the credit card, but it's the same amount and the same credit. The credit card, the name of the credit card is the same as it was associated with the numbers. But all of which is to say, the debt that's being duplicated is 182,188. So, if you look in the middle of the page towards the bottom,
Mr. Conway-Lincoln.
316.
Second. I mean, do you all agree on this mathematical correction?
I don't know if she does or not. I just showed it to her today because I just did it today because I was getting ready for this, so I'm sorry.
I cannot stipulate the figures because I haven't had it, like you said, I just got it today.
Okay.
We both agree that there's duplicates of the debts. I mean, it's exactly probably.
And again, what's in green adds up to 182, 188 too. So you could see that that's where the duplication comes from. And towards the lower portion of the page, you'll see the 182, 188 adding 2,290 and 3,120. If you will look back at page 315, the top number is 2,290, and the bottom number on page 36 is 3,120. So those are two ones that are not repeated and are not duplicated, but they should be added to the debt. So the total debt that's been allocated is $187,598, because I've done the tape with the 182, 188, and the 2,290 and the 3,120, and you end up with a negative number of total debt of $187,598. So what happens then is, what was the net difference of being a negative $119,315 actually ends up being a negative $31,746. And if you'll notice underneath the $31,746 negative number, I have inserted, this is not on the record, I have inserted the difference of just a mathematical number of $87,569. All of which is to say is the number that's in my brief, or our brief, in the sense that that number is what we say is to the benefit of Mr. Jensen, in the sense that he otherwise would, if the judge found it equitable at the time to award him the debt of the $250,471, obviously this is much less than that, so I would assume it would be equitable as well.
Excuse me for interrupting.
Sure, please.
Counsel. I presume these figures are consistent with the numbers that are reflected in your brief.
They are. In the sense that, in fairness, in my brief, I don't list the individual numbers, I list the aggregate numbers, and it's on pages 28 through 31 of my brief that this discussion occurs. And so that's where I've referenced this, and that's where I've come to the conclusion of the $87,000 benefit is what I say that he received as a result of this mathematical error. So, and in fairness, there is a second issue with the judge's decision, and that is on the alimony. She did go through all the alimony factors. She judicially found he was underemployed. She judicially found that he had the ability to make more. She made those determinations. She included those in her opinion. She put $100 down and made it modifiable to obviously provide for some protection for my client in the event that he did start making more, so that she could reapply if she needed to. But it is characterized as transitional alimony, which is modifiable, and it should have a definite period. There is at least one justice who sits on the bench is somewhat familiar with Lund v. Lund, where we changed the transitional alimony in that case to correct the judge's characterization of it as transitional alimony, and that particular judge made it in futuro. And so, with regard to that particular case.
What is your client's position with regard to, what are you requesting?
Well, my requesting is, I would suggest 8 years if you're going to do a definitive period, or if you want to do alimony in futuro, there's a change of circumstance, like if she gets married or whatever, because that's likely. She's an attractive lady and has 2 children, but some of us would say that's an asset, some of us would say that's a liability. But anyway, so again, that's the issue, and I'm trying to avoid the cost, to be blunt, of a remand with regard to those 2 errors, and so that's why I'm suggesting corrections at this level. I can go on with regard to these issues, all of which you all are familiar with. I'm happy to answer any questions. I mean, it's clear what you did on the alimony. It's clear what you did on the division of marital assets. This question about dissipation, I don't know if you all have looked at this record, but this record consists of 3 boxes. What happened was there was a summary exhibit, which was Exhibit 6 and 7, and 8, I think, that are all related with regard to the dissipation issue, and those were summary in nature. I had, at the trial, all of the credit card statements, the bills, whatever, in case there was a need under Rule 1006 for cross-examination of those. For whatever reason, no offense to Ms. Bowman, because she was not the attorney in attendance, for whatever reason, Counselor Mr. Jensen insisted that we include all of the records that I had available rather than as exhibits. So you have, unfortunately, a host of exhibits. I don't know that you necessarily, you can wade through them, but I'm just saying your clerks will have a lot of fun. So, because there's a lot of records there, and they do support what we say, and I'm over time, and I apologize.
Okay, let me ask you a question, though. Be sure I understand. The trial court found that the husband was underemployed,
Yes.
voluntarily underemployed. What did the trial court find husband's income to be when he was doing the calculations of?
She had tax returns for the prior 2 years, and what she did is she took the 2 prior years of those tax returns and averaged them with his current income, and that's how she came up, but she did an average of 3 years with regard to that, and so that's how she came up with his income, and she says that in her opinion.
Okay.
So, and it's in the testimony. To be blunt, it was a well-tried case by the judge, and you know, I'm sorry she made the math area that she did and the transition out.
Okay. All right. Court's thanks to both counsel. We appreciate it.
Your Honor, may we be excused?
Yes.
What about the box? Are you going to put it back?
Yeah.